The Oklahoma Real Estate Conference was on Monday, and I had a great time seeing many of you out there and getting a chance to briefly talk about some of the things going on in the industry, about the NAR settlement, and some of the things that are coming down the pipeline that you may not be aware of. And shout out to these super cool cups that we got for the conference. But there was a section of my session when I spoke where I answered questions and people could submit them. And unfortunately, I wasn't able to answer every single question. And man, I hate that. I hate leaving questions that people have hanging. And so thought I would record a little bit of a video answering those questions that people had, including the ones that were already answered there, just so everybody knows exactly what those answers were. And this will maybe help you fill in a few gaps on questions that people had about the NAR settlement and things going on in the industry. So listen, the studio's in a little bit of a mess. I got to put some things back together. And so I hope you'll join me as I kind of pick up around here and answer these questions that people had. So the first question is, what are the rules around procuring cause if a buyer signs multiple buyer agreements with different brokers? And this is a really great question. And here's the deal. Procuring cause, for all intents and purposes, in my view, doesn't really exist anymore. If you think about how we got paid in the past, procuring cause basically said, if you are, submitting an offer on a property, and before, we always had compensation listed in the MLS. And the way those compensation rules worked was that if you are the procuring cause, which means you're the agent who set forth the chain of events that ultimately led to that buyer purchasing the property, then you were entitled to compensation. And when we would put the compensation in the MLS, that was a binding offer of compensation to anybody that brought a buyer. And as soon as I submitted an offer, we didn't have to have compensation in the contract or anywhere else. Just being in the MLS, if I was also a participant in that MLS, that offer of compensation became binding as soon as I submitted my offer. And that, worked for a while, but now we're in the situation where the offer of compensation, there isn't one in the MLS. And so that means things have pretty drastically changed. It means that when I submit an offer, there's no binding offer of compensation. And instead, we're in this world where it all depends on who has the agreement in writing, which means it probably should be in the contract between the buyer and the seller. Or if I am for some reason still doing broker to broker compensation, then it better be in some sort of contract between me and the broker. The idea of me being the procuring cause, it just sort of doesn't really matter anymore. The next question, is it true that one of the attorneys involved in the NAR lawsuit is now part owner of a flat fee real estate brokerage? And I'm not sure about the attorney, but it is true that one of the plaintiffs in the case, the Sitzer-Burnett case, Josh Sitzer is his name. There's an article here on Real Estate News, but you can kind of search for this, is involved with a company that is in fact a startup company in that world. So there is some truth to that for sure, that they're, involved with some sort of new real estate brokerage, trying to change the way that business is done. And, I get that may feel like a problem, or you don't like that and feel like there's ulterior motives here, right? That is the reason that they got involved in the lawsuit because they're actually a harmed plaintiff, or is it because they had this other business interest? And, look, you can draw your own conclusions from the lawsuit and that fact. But at the end of the day, whatever, right? Doesn't matter. I mean, that was just one of the plaintiffs, and there were multiple plaintiffs in multiple cases all over the country. And I don't think that necessarily changed the outcome. I think that's just kind of, it is what it is. And you know what? I'm confident in my business model, and I want you to be confident in your business model too. And so, yeah, there's people out there that have different business models, and that's okay. And we just have to all compete. And the thing is that if you believe in your business model, if you think that it's best for buyers and sellers, then go out there and sell it, right? Doesn't matter what anybody else is doing. I mean, it's a beautiful thing. This is America, right? We all get to compete and do our own thing. And so whether somebody was involved or not, at the end of the day, I don't think it matters. We just got to go out and do our best to protect and promote the interests of our client and sell our business model to them. And if they think it's good, then they're going to keep using us. This question is a little bit touchy, and here's what they asked. They said, how do you feel about agents coaching their buyer clients that it's in their best interest to give the agent permission to filter listings based on compensation instead of coaching them that every term is negotiable and they should focus on finding the right property first and then negotiating compensation? I think here, well, let me say this. I think that filtering listings based on compensation, especially when you put it in those terms, that's explicitly a violation of the new MLS rules and practice changes that went into effect. And I know people have said, well, look, it's the buyer making the decision. The buyer does get to make the decision, that's for sure. But a lot of smart people out there, people smarter than me, have weighed in on this and said, look, it's a violation to have a directive from your buyer that says, filter listings based on compensation. Okay, because that is what we're doing here if we have that kind of directive, to not show them or send them listings based on the fact that there's not compensation explicitly being offered. And the MLS rules say that you can't filter listings by compensation. It doesn't say you can't filter listings by compensation unless directed by the buyer. Instead, the way the rules really are contemplated is that you're going to send them the listings, you're going to give them all the information, and there's nothing inherently prohibited or not allowed about calling and asking about compensation, but that you should not make the decision at that point whether to send it to them or not, even if the buyer told you not to. That really what we should be doing is saying, look, I'm going to try to gather that information for you if that's what you want to do. Some people aren't doing that. And if you are, say, look, I'm going to gather the information, I'm going to send it to you, and then buyer, you get to decide which properties you want to go look at. And after you've gathered the information and said, look, this one is offering this amount of compensation and this one said this and this one said that and whatever, then the buyer gets to make the decision rather than us having that decision made up front. So I don't recommend doing it. I know what's happening. I know what's going on, and I think it will probably continue to go on for some time, but my recommendation is not to do it. I think I agree that it is still filtering listings by compensation, and that is prohibited by the rules. So I don't know that it's a good idea to do. I think you're setting yourself up for some potential problems if you're doing it. But I'm not really here to tell people how to manage their business. It just does pose some risk for you that probably isn't worth it. Okay, so the next question is, if I have a listing and get a sign call, Oklahoma isn't a dual agency state, which is true. We don't have agency in the state of Oklahoma. Do I need to get a buyer broker agreement signed? So if I have a sign call from a buyer who says, can you show me the property? Do I need to get a buyer agreement signed? And if they then want to put in an offer, do I need to get a buyer agreement signed? So first question, do you need to get a buyer agreement signed? Well, here's the deal. The rules basically say that if I have a listing and a buyer calls me off of my sign and says, hey, can you show me the property? Well, technically, then I'm working for the seller and I'm not working with that buyer yet, and so I don't have to get a buyer agreement signed at that point, simply because I am showing that property on behalf of the seller. I'm not working with that buyer yet. So purely from a sign call, no, I don't think that you have to get a buyer agreement signed. The buyer then wants to put an offer on. It gets a little more complicated because the Broker Relationship Act says that, you have to, at the request of any party, reduce an offer to writing. So if a party requests, and it's any party, it's not just the party that you're providing brokerage services to. So that kind of complicates things a little bit, right? Because if you are not providing brokerage services to that buyer and instead you're just working with the seller, do you have to get that buyer agreement signed? Well, it raises a question, because the question really is, are you going to be working with and providing brokerage services to that buyer? Because I think at the end of the day, just reducing it to writing is a legal duty that you have, but the question then is, what else are you doing? Are you going above and beyond that to provide additional brokerage services to the buyer? In which case, yeah, now you're working with the buyer. And so that means you need to get a buyer agreement signed. Tell us about the change with the Real Estate Commission that makes our forms exclusive. Well, so the Real Estate Commission just this last week, they made a change to where if you want to get access to the contract forms on their website, you've got to log into your license portal to get the link to where the forms are. Right, before you could just go to the Real Estate Commission's website and get access to the forms. They were right there publicly available, and that's no longer the case. And so instead, again, you got to log in, and then there's a link in your license portal that says contract forms, and you click there and that'll take you to it. The question is why? Why did that change? Well, I don't know all the details, except I do know that the law that says the Real Estate Commission is going to create forms and have a contract forms committee, it says that the Real Estate Commission shall have a contract forms committee that creates forms for use by real estate licensees. It doesn't say to create forms for use by anybody and everybody that wants them. And so it is specific to real estate licensees. So I think that maybe had something to do with it. Again, that's kind of what I've heard. I haven't necessarily talked to them about it. But that's what you can expect. There's also, I will say, some of the forms are still publicly available right there on the Real Estate Commission's website. It's primarily like the lease forms, which is good because there's a reason to have forms like that available to the public, because there's a lot of really bad leases out there and they're just illegal leases, frankly. So having a vetted lease is good, but yeah, pretty much all the rest of the forms, the purchase forms and the commercial forms and land and all that sort of stuff, all that's now, you got to log into your license portal. On the left side, you can click contract forms, and then there's a link there that'll take you to them if you need to get those on the Real Estate Commission's website. I swear I'm going to hang this thing soon, I hope. All right, so the next question is, do you see any changes coming to commercial real estate? And not like what we saw in terms of these practice changes, because with commercial real estate, they don't have the same issue. They've never really done offers of compensation in the MLS and all this sort of stuff like you saw in residential. Commercial's always done things kind of the way residential's now shifted with the practice change. So in terms of anything major happening in commercial real estate, I don't. It's a whole different ball game in commercial. A lot of times the buyers and sellers will have their own attorneys that are involved and due diligence and all these sorts of things that are quite a bit different. So no, I don't really expect anything to change in commercial, not anytime soon. All right, will there be any ramifications if an agent has a buyer sign a buyer agreement and doesn't explain it to them and maybe has them sign it without their knowledge? Heck yes, there will be ramifications. Look, please don't get buyers or sellers or anybody to sign something that they don't know what it is. And I think that you have an obligation to at least do some sort of explanation. All right, so you're showing houses to somebody and the question is, who all do you have to get to sign the buyer agreement? Mom and dad are tagging along, they brought a friend, do they all have to sign the buyer agreement? Here's my opinion on that. No. The question is, who's the buyer? Who are you working with, right? Because the analysis here is two parts. First of all, it says when working with a buyer, you have to get them to sign a buyer agreement no later than when showing them a house. So the question is, who are you working with, right? Who's the buyer? Mom and dad tagging along aren't buyers. They're not buying the property. The friend that comes along, they're not a buyer. They're not buying the property. So instead, you have to question who's the actual buyer, and I think that's who you get to sign the buyer agreement, right? You're in a college town. You're showing somebody a property. Maybe they're gonna buy it and they're bringing their two sorority sisters to come check it out. I don't think they have to sign a buyer agreement because they're not buyers. They're just there. They're just people. You're not working with those people. And so I don't think there's any obligation to get them to sign a buyer agreement at that point. So really, take a look at that as to who are you working with? Who is the buyer, right? Because whoever the buyer is, that's who needs to sign the buyer agreement. All right, last question. And it comes from somebody who was there as a non-realtor agent, right? Because look, remember, not all real estate agents are realtors. To be a realtor, that means you've joined the Realtor Association. That's the definition. So the question is, what has the Real Estate Commission done? What is law? What is rule? What's the difference? What's actually going on here? And if you're a non-realtor, here's the thing. the changes that went into effect, it was the Realtor Association that made the changes. And the changes that were made were in the MLS rules. So the correct way to say it is not necessarily that these practice changes only apply to realtors. Instead, it would be the practice changes apply to MLS participants in the MLSs where the rules have changed. Because it's actually not the code of ethics, it's not anything specific to the Realtor Association. Instead, it's the MLSs, and it's the MLSs that were like realtor-owned MLSs who had these practice changes. And there were some non-ones who opted in and some opted out and all that kind of stuff. At the end of the day, the question is, are you an MLS participant? And if so, what are your MLS rules? What changed was not the law. This wasn't a federal law, wasn't state law, wasn't the Real Estate Commission rules, had nothing to do with the law that changed. It's the MLS rules that changed. And before you get out of here, it's the last second, you may have already left, please don't leave. Please like and subscribe. That helps me know that this was valuable to you and you got something out of it. I appreciate everybody who came to the session that I spoke at over lunch. It was lunch, so you kind of almost had no choice if you wanted to eat. Appreciate you guys being there. I hope that I shared some stuff that was valuable. I hope that this follow-up with some of these questions being answered was valuable and highlighted some of these important things and those changes. And you know what, shout out to Curtis Kupfersmith, who planned this Oklahoma real estate conference. He's been doing this for a number of years now, and it's just getting better and better and better every year. Huge thank you for having me come out. I'm honored and I appreciate that. And if you weren't there this year or in prior years, shame on you. You better be there next year because he's gonna do it again. He's coming back. It's gonna keep happening. And this is an amazing conference that you wanna be a part of so you can be on top of the game. So definitely check it out in the future. Shout out to him and thanks for having me. And if you have any other questions, leave them in the comments down at the video, below the video. I will try to answer those in a future video because that's what we do here.